Well, the federal government has committed $4.5 billion to purchasing Kinder Morgan's Trans Mountain Pipeline. It also says it will cover the cost of the pipeline expansion. Many pro-pipeline advocates have been celebrating that decision, but the purchase doesn't change the fact that the Trans Mountain expansion project still faces a number of challenges in our courts. Those include the province of BC's reference question in BC Supreme Court and the challenge from the Tsleil-Waututh Nation and many others in the Federal Court of Appeal. Now, Jack Woodward is a BC-based Aboriginal rights and constitutional lawyer. He worked on the landmark Tsleil-Waututh case for 25 years, and Jack is with us on the line from Campbell River this morning. Good morning to you, Jack.
Hey, good morning, Stephen.
Your reaction first off to the news that the federal government is now buying the Trans Mountain Pipeline, $4.5 billion to take over the infrastructure and many billions more to finance the expansion.
Well, it doesn't make any legal difference. They solve their business problems. You know, the company was getting discouraged, and so now there'll be federal money and federal encouragement into building it. But they have all the same legal problems. It doesn't solve a single legal issue.
It was suggested yesterday by BC Liberal leader Andrew Wilkinson that it does change the face of negotiations with First Nations since the government, which can rewrite legislation, is now in charge of the project.
Well, I think that makes it harder, not easier, for the federal government because now they have direct obligations, crown obligations to solve the issues with the First Nations, and they can't delegate those to a third-party corporation. But you start first of all with the provincial jurisdiction. Nothing changes in terms of the province's jurisdiction to regulate for hazardous substances and health and safety and local issues like that. So it doesn't matter whether it's owned by the federal government or owned by a private company. The Aboriginal issues are also unaffected by who owns the pipeline, but I think it might even make it harder for the federal government to put it through because they have a direct obligation as the Crown to deal with the First Nations honorably, and coming in waving the club of being owner won't make them look good in the courts. It'll place a higher bar in terms of their behavior in this regard.
Do you think that's a significant consideration for this government?
Well, for the federal government, you mean? Yeah. I think. Prime Minister Trudeau said that by purchasing the pipeline, his quote is, a lot of the legal barriers and a lot of the challenge points disappear. And I just can't agree with him. I think that he's created more problems in trying to build the pipeline and not less by purchasing it.
Now that the government and its citizens are the owners of this pipeline, I mean, are we now on the hook for the project financially? I mean, is there a chance that this could be a money loser?
Oh well, of course. It's obviously the company was running for the exits, and the government has bailed it out. But that's a business decision, and I'm not really commenting on that. I'm just commenting on the legal side of it, which is that this is under the new spirit of cooperative federalism that's been emphasized over and over again by the Supreme Court of Canada. Nobody gets to be the constitutional bully. And so Canada has assumed that role, unfortunately. I'm surprised that they are acting like they can run the show. And this will eventually reach the Supreme Court of Canada through one of the many, many different court cases challenging this pipeline. And we can be assured that the Supreme Court of Canada will start with the proposition of cooperative federalism, and they'll say to Canada, how have you been cooperative in this regard? And Canada's got an even worse answer than they had the day before yesterday. They can't say it's cooperative to try and bully their way through this. They have to figure out, in order to be successful here, they have to figure out how to accommodate British Columbia's legitimate concerns about the environment. And this is the opposite of that.
And we have heard the federal government focusing very much on the opposition from Premier John Horgan. When they hold news conferences, when they answer questions from reporters, they are virtually silent on the First Nations opposition to this pipeline.
Yeah, and that is a surprise because, they have embraced the principles found in the United Nations Declaration. Canada was a big part of drafting that United Nations Declaration. The federal government has embraced those principles, and yet now the Minister of Indigenous Relations is clearly backing away from that. She has relied on the fact that 33 First Nations are in support of the project, but this is not a majority rules kind of situation. The First Nations that are opposed to it have legal bases for that. They have concerns about the environment that affect their own rights, and they're often specific to the location where they live. It's, there's not a one size fits all cookie cutter approach here. Each First Nation has, British Columbia has a complicated geography, and so each First Nation has its own concerns about how a pipeline spill might affect their area, including First Nations in the interior. And so it's very surprising to hear the Minister of Aboriginal or Indigenous Relations come out, that's the federal minister, come out and say that she thinks that there's enough consensus. Well, that's just not how it works. I mean, you have to, there's no vetoes. We agree that there's no vetoes, but you have to find out how to accommodate each and every First Nation, and any one of them. There's 14 challenges, but any one of them could put an end to this pipeline. It's just not the right approach. I'm so surprised that the federal government is taking this, what I call a sort of a bully approach, because that's not the way the Constitution is done in the 21st century.
Early on in the case set forth by the Tsleil-Waututh Nation, it refers to the Supreme Court decision of 2004 in Haida Nation versus BC, which ruled on the duty to consult with Aboriginal peoples and accommodate their interests. How does that Supreme Court ruling play into this ongoing case?
Well, that's one of the two fundamental points. So yes, there's for those First Nations that have not yet established their rights, but that are in the process of doing so, like the Tsleil-Waututh, they can rely on this. It's a very well established and powerful body of law that says that the federal government has to consult and accommodate in accordance with the honor of the Crown. That's part of it. There's another part of it that's even more potent and hasn't been mentioned, which is that the law, that is the law that the federal government will pass to make this pipeline possible, has to be justified. It has to be justified in the interests of the First Nation, not just in the national interest, but also in the specific interest of the First Nation. And they'll never get over that hurdle when they're behaving the way they are. They must have legal advice, and I don't know why they're ignoring it, because their legal advice will be telling them you can't barge your way through this over the objections of all of these people. You have to accommodate them in some way or the other.
Jack Woodward, it's good to hear from you this morning. Thank you so much for taking the time with us.
You bet, Stephen. Anytime. Thanks.
You take care. Bye-bye now.
Yeah.
That's Jack Woodward, a BC-based Aboriginal rights and constitutional lawyer. He worked on the landmark Sokoteen case for 25 years.